What is this? It is the establishment of a copyright small claims board, a whole agency-like thing, a whole entity that is just going to handle copyright small claims. So a copyright small claims court. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hello everyone, I'm Leonard French, your favorite copyright attorney, and I've got a special one for you here. We have legitimate substantive changes to the copyright law as you know it. The Copyright Alternative in Small Claims Enforcement Act of 2019 has passed the United States House of Representatives 410 to 6. So that's a pretty remarkable margin of, I guess, favorability there. And look at the co-sponsors. The co-sponsors have just blown up into 150 some co-sponsors, 152. So I thought maybe we should look at the act that was passed by the House. This is likely the way it's going to be passed by the Senate. And if it is signed into law by the president, then you have new copyright law, and it's a lot. There's a lot of changes here. We should review this. This is really important. So let's get started without further ado. So this is the PDF printout. We're going to move through this fairly quickly, so try to keep up and feel free to go back or slow it down if I move too quick. And of course, if I'm too slow, you know who you are. Feel free to speed me up with the settings in your device. So this act is to amend Title 17, United States Code, which is the Copyright Act, to establish an alternative dispute resolution program for copyright small claims. And you can see there's now a lot of supporters here in the United States House of Representatives. In case you didn't see it before, there's the same thing we just read. It is called the Copyright Alternative in Small Claims Enforcement Act of 2019. We're going to keep calling it the CASE Act. And here are its new sections. It adds a chapter 15, kind of like the DMCA added a section or chapter 500 and then added a section 1200 for the anti-circumvention, safe harbor provisions and things. This is adding a section 1500 et sequitur. So definitions, the establishment of a copyright claims board, the authority of the board, how proceedings occur, what the registration requirements are, because remember, there are now registration requirements. You can no longer sue in the United States without having a copyright registration certificate. The effects of the proceedings, the review and confirmation by a district court, the relationship to other district court actions, implementation by a copyright office. What is this? It is the establishment of a copyright small claims board, a whole agency-like thing, a whole entity that is just going to handle copyright small claims. So a copyright small claims court is what this is, nothing less than that. So there's some definitions here, but we're going to skip fairly quickly. So in general, there is established in the Copyright Office the Copyright Claims Board, which shall serve as an alternative forum in which parties may voluntarily seek to resolve certain copyright claims. The Copyright Claims Board is made up of copyright claims officers. 3 full-time copyright claims officers shall be recommended by the Register of Copyrights in consultation with the Librarian of Congress. 2 copyright claims attorneys will be appointed or hired by the Copyright Claims Board, or it doesn't say exactly who hires them here. The copyright claims officers must have 7 years of legal experience in substantial evaluation, litigation, or adjudication of copyright infringement claims, and between those 2 officers should have presided over a diversity of copyright interests. The copyright claims officer not described above shall have substantial similarity with copyright law and experience in a field of alternative dispute resolution. So there's going to be 3, I think it was 3 officers, and they have to have a diverse background between the 3 of them. And then the copyright claims attorneys shall have not fewer than 3 years of substantial experience in copyright law. The officers are paid like senior level employees of the federal government. I don't know exactly what that is, but the attorneys are paid level 10 of the GS15 general schedule, which I was able to figure out what that was. And that looks like this. Level 10 should be this $138,572 a year. I guess that's before taxes. The copyright claims officers shall serve for a renewable term of 6 years, but they're going to start with an offset. The first one's 4 years, second one's 5 years, third one's 6 years, and then I guess they're going to start the schedule from there. And that way they're offset. There's terms for how the Librarian of Congress may sanction or remove a copyright claims officer under certain circumstances. The functions of the claims officer, this is kind of the meat or the heart of what they're allowed to do. They render determinations on civil copyright claims, counterclaims, and defenses. They ensure that claims, counterclaims, and defenses are properly asserted or otherwise appropriate for resolution. They manage the proceedings before the officers. This is the copyright claims officers manages the proceedings before the officers, okay, and renders rulings pertaining to the consideration of claims, counterclaims, and defenses, including scheduling, discovery, evidentiary, and other matters. They request from participants and non-participants the production of information and documents relevant to the resolution of a claim, counterclaim, or defense. They conduct hearings or conferences. They facilitate settlement. They award monetary relief. They might include sort of an injunction of sorts that includes a requirement that certain activities cease or be mitigated if a party has agreed as part of the adjudication or final determination. They provide information to the public concerning the procedures and requirements of the board, and they maintain records. The attorneys, the copyright claims attorneys, provide assistance to the officers in the administration of their duties. They provide assistance to the members of the public with respect to the procedures and requirements of the board, and they provide information to potential claimants when contemplating bringing a permissible action about obtaining a subpoena for suits under 512H, which is a suit to uncover the identity of an alleged infringer. The Copyright Claims Board shall render determinations of the board in individual proceedings independently on the basis of the records in the proceedings before it. It's more of just a standard language establishing a tribunal. Any party to a proceeding before the board shall refrain from ex parte communications, which means you can't communicate with the judge, or in this case the board, without also telling the opposing party. And actions of the officers and Register of Copyrights are subject to judicial review as provided under Section 1508C, which is all about misconduct and things. We'll get to it. They go over the nature of the proceedings. It's a voluntary thing. It has a statute of limitations, which is similar to copyrights, 3 years. They go into what kind of claims you can bring: a claim for infringement, a claim for a declaration of non-infringement. So these are important. These are the standard copyright claims. A claim for a misrepresentation under 512F, and various counterclaims that arise out of the Copyright Act, Section 106 or 512F. Section 106 is the copyrights. Section 512F is that misrepresentation in a takedown notice. There can be a monetary recovery of actual damages, profits, and of statutory damages. This wasn't entirely clear in the previous versions of the Act. You do have statutory damages inside the Case Act. Statutory damages are limited, though. They may not exceed $15,000 for each work infringed. So that still allows for things like the BitTorrent John Doe copyright infringement lawsuits that I do. The damages, while not exceeding $15,000, still end up being quite high because the plaintiffs sue for multiple infringements. So even if it was $15,000 for each work infringed, how many works do you need before you're up to $100,000? Well, yes, 8 8.5 works would be the answer there. The point is that this doesn't make it easier for my defendants, is what I'm thinking of in my head. And then there are some works here that are 7,500 per work infringed, or a total of 1,500, and that's for works that are not timely registered. So if you do have to register your copyrights, that will still be in here. We'll get to that in a moment. So if you don't timely register it, then you can't sue for statutory damages of more than 7,500 per work or 15,000 for any one proceeding. So I'm assuming that means that you did register your work, you just didn't timely register it. And this is important, the Copyright Claims Board may not make any finding about infringement being committed willfully. They can't triple or treble statutory damages like many courts do, considering it to be a willful act. So this actually does limit. That 15,000 I was talking about before would not then be tripled, which is a good thing. That's a good thing. It's still a lot of money, but then it's at least not going to be triple that. The Copyright Claims Board is allowed to consider whether the infringer has agreed to cease or mitigate infringing activity when considering statutory damages. The claimant or counterclaimant shall elect whether to recover actual or statutory damages at the commencement of the claim or at any time before a final determination is rendered. So, or they can elect not to recover damages because, we sued, but we aren't going to recover damages. That makes sense. It does if you are asking solely for that injunctive relief. And remember, this is all voluntary, so you have to get somebody to understand that they're being sued for this kind of copyright infringement or whatever kind of copyright infringement in this kind of court, I guess is what I mean. And then agree like, hey, if you agree to not infringe anymore, then we'll drop it here and we don't have to take you to district court and that'll save everybody a whole bunch of money and headache. Yeah, maybe that'll wake some defendants up. I'm not entirely sure. Others will just flaunt it. Damages for other claims shall be limited. Total monetary recovery cannot exceed $30,000. And this is just a skimming, so don't take this as legal advice so much as a general awareness that this is coming down the pipeline. We'll do a more comprehensive evaluation once the thing becomes law. You as a party can agree to cease certain activity found to be infringing or cease sending takedown notices or cease making material misrepresentations. You can lose and find yourself bearing your own attorney's fees and costs only if you are guilty of bad faith conduct. So no attorney's fees and costs shifting if there's no bad faith conduct. Parties can be jointly and severally liable. What does that mean? That means that if there's multiple defendants liable for the same infringement, they are all fully liable for the whole thing. Now, that doesn't mean that, let's take the hypothetical where there's 3 defendants. That doesn't mean that the plaintiff gets to recover 3 times, but it does mean that if the plaintiff can recover from one of the 3, if they can recover the whole thing from one of the 3 defendants, well, that one defendant is on the hook for the whole thing. So would be either of the other 2. Whoever basically can pay for the thing gets to pay for the thing, and then it's up to the 3 of the defendants to figure out who should have paid for how much, and that can be a different fight among them, more or less a 30,000-foot view of joint and several liability. There is a registration requirement. A claim may not be asserted unless the owner of the copyright has first delivered a completed application, deposit, and fee, and the registration certificate has either been issued or not refused. So that includes a pending application. However, you can't get a final judgment until that certificate is filed with the board. So a claimant or counterclaimant in a proceeding shall be eligible to recover actual damages or statutory damages, except that the board may not render a determination until the certificate of registration has been issued, approved, and been filed with the Copyright Small Claims Board. The other parties have to have an opportunity to address any deficiencies with the certificate. If the proceeding may not proceed further because the certificate is pending, the proceeding shall be held in abeyance. If it is still pending after 1 year, the board may provide written notice and then dismiss the proceeding. If the Copyright Claims Board receives notice that the registration has been refused, it is also dismissed without prejudice. And without prejudice means the claims have not been adjudicated and the case can be filed again. They go over the conduct of the proceedings. There's a centralized process. There's a record. The board will conduct the proceedings more or less online or electronically through the offices of the Copyright Claims Board without the requirement of in-person appearances by parties or others. The submissions take place by means of written submissions, hearings, and conferences carried out through internet-based applications and other telecommunications facilities. The Copyright Small Claims Board may make alternative arrangements for the submission of evidence. Representation is limited to by attorneys or by law students who are qualified and are representing on a pro bono basis. Pro bono, of course, meaning free. Free or for the good of the profession, basically. For the good of the, well, pro bono just means for the good. Commencement of proceedings, they talk about how you start a proceeding. You must include a statement of material facts. You must certify that statement. Certification means like affidavit or verification under oath, like I, Leonard French, solemnly swear that the foregoing facts are true and correct under penalty of perjury, so help me, higher deity, something like that. And must be accompanied by the filing fee. Upon filing of the claims, the copyright claims attorney reviews them. If the claims are found to comply, great. But if they don't comply, you get 2 more bites at the apple. You get to amend within 30 days a first time, amend within 30 days a second time, and then a third time the thing, if it still doesn't comply the third time, it will be dismissed without prejudice and needs to be refiled and the fee repaid. The counter claimant or respondent gets the same privilege. You can bring claims against an online service provider subject to limitations of liability in the DMCA, so safe harbor provisions and all that. Here's the part about the counterclaims given the same timing privileges. The Copyright Claims Board shall dismiss without prejudice for unsuitability, the failure to join a necessary party. That's Federal Rule of Civil Procedure 19, so you can't, this rule can't override that rule, right? This law can't override that law. So the failure to join a necessary party is in there. The lack of an essential witness, evidence, or expert testimony can make a proceeding unsuitable. The determination of a relevant issue of law or fact that could exceed either the number of proceedings the board could administer or the subject matter competence of the Copyright Claims Board. So in other words, if you get a Richard Leibowitz or a Malibu Media or a Strike Three Holdings and they file thousands and thousands of suits in the Copyright Claims Board, maybe they will be determined to be unsuitable because the board just can't handle thousands. I don't know. It's kind of a vague paragraph. The competence would also be the other reason. If there were questions of law or fact that are just so complex that they can't be answered by a small claims court, then they would go to the district court instead. They would be determined unsuitable here. They go over service and notice of claims. Basically, the service and notice interesting fact here, or interesting law, I guess, by not opting out of such a proceeding within 60 days, the respondent, not the claimant, but the respondent, the defendant, loses the opportunity to have the dispute decided by a court created under Article 3, or loses the opportunity to go to district court instead, is what that means. There's an actual correct reference to Article 3 courts. Edward Thomas Kennedy, eat your heart out. The respondent would also waive their right to a jury trial regarding the dispute, again, if they don't respond by opting out. So if you get served with a copyright small claims notice and you don't opt out, then you are in. It's an opt-out system. It's an automatic in if you don't opt out. FYI. Notifications, the Register of Copyrights establishes how the notices are sent and all that, but we're also not going to go over that. We'll go over all that in detail when the act is finally passed by the Senate and passed and signed into law. A proceeding may not include any formal motion practice, so we're not going to be doing motions to dismiss. We're not going to be doing motions to quash subpoenas or something like that. It's basically a small claims court and therefore is a little bit informal. They still follow the discovery rules, but the discovery in a proceeding before the Copyright Small Claims Board is limited to the production of relevant information and documents, written interrogatories, and written requests for admission. That means no depositions under oath. Everything's going to be written questions, which is called interrogatories, or written requests for admission, which is yes or no questions under oath. Except upon the request of a party and for good cause, the Copyright Claims Board may approve additional discovery on a limited basis in particular matters and may request specific information and documents from participants in the proceeding and voluntary submissions from non-participants consistent with the interests of justice. Same with the request for a party in good cause shown. They may issue a protective order, so we can still do protective orders, even though there's no other motions practice. And why would you use a protective order? Well, you might protect a party's confidentiality or a party's name or something like that. If something, you have to have good cause. So the facts have to show it. I can figure out one on the top of my head. I represent defendants in John Doe matters. They start out as John Does, and then they're accused of downloading, shall we say, adult entertainment. Well, who wants their name next to accusations of that nature? So a lot of courts will grant protective orders allowing the defendant to remain John Doe. The parties and the court still have to know who you are, but the public doesn't in cases where good cause has been shown. The Claims Board may also apply an adverse inference with respect to disputed facts when a party has failed to timely respond by providing discovery materials. So if you've received a discovery request and you don't respond, the judge can assume, or rather the board here, can assume that you didn't respond because the facts you're responding with, let's say that somebody wanted to request a copy of correspondence that I had with my team regarding the use of a photo in a video or something like that. Maybe there's an accusation that I didn't make it a fair use or whatever. So if I don't respond to that request, then the judge can assume that the correspondence that was requested says something against me, like, yeah, I don't care if it's copyright infringement, just go ahead and use the image anyway. Something like that. The Copyright Small Claims Board may consider documentary and other non-testimonial evidence that is relevant. Remember, relevant evidence makes a claim or defense more true or less true, and that makes it relevant. So if it weighs on a fact in a case, then that testimony or evidence is relevant. Testimonial evidence submitted under penalty of perjury in written form is allowed, limited to statements of the parties, non-expert witnesses. The Copyright Small Claims Board may conduct limited hearings, which shall be attended by not fewer than 2 of the officers, and I guess there must be some kind of need for said testimony, and a record or transcript shall be available. A plaintiff or claimant can voluntarily dismiss. There are no class actions before the Copyright Small Claims Board, and the parties are allowed to settle their case before the Copyright Small Claims Board. I'm a little unclear whether this paragraph here means they have to submit the settlement agreement or submit an agreement that says we're settling. Doesn't mean you can have private settlement agreements. I think so. I wouldn't see why you wouldn't have private settlement agreements, but who knows? The Copyright Claims Board makes factual findings. A determination in a proceeding shall be reached by a majority of the Copyright Claims Board, so it's just a simple majority. The determinations must be in writing and include an explanation of the factual and legal basis for the determination. Any dissenting officer may append a dissenting statement. Each final determination shall be made available on a publicly accessible website. They'll respond to Freedom of Information Act requests. In the event of respondent's default, the Copyright Claims Board may enter a default determination, but they're a little bit generous here. The claimant must submit relevant evidence and other information in support of their claim. The board will prepare a proposed default determination and then provide it to the defaulting party. The notice shall be accompanied with the default determination, provide that the respondent has a period of 30 days to respond to the notice of default. And if the respondent responds, then the Copyright Small Claims Board shall consider respondent submissions. So you get another bite at the apple there. If the claimant fails to proceed, they get something like 90 days to figure it out. If the Copyright Claims Board denies a party a request for reconsideration after a final determination, then that party may, within 30 days after the date of denial, request the Register of Copyrights review the decision instead. If there's bad faith conduct, then we start awarding money up to $5,000 in reasonable costs and attorney's fees to any adversely affected party, adversely affected by bad faith conduct. But a pro se party is only worth $2,500, up to $2,500. A pattern and practice of bad faith conduct can result in an award of attorney's fees in excess of those limitations. Issuance of a final determination by the Copyright Claims Board in a proceeding may be relied upon in future cases unless it's not finally determined, and that the Copyright Claims Board does not determine ownership of copyrighted works, and more about misconduct and misrepresentations there. So no class actions again. In any proceeding in which a party has failed to pay damages or failed otherwise to comply with the relief awarded in a final determination, including a default judgment, and not later than 1 year after the date on which the final determination is issued, the aggrieved party may apply to the District Court for the District of Columbia or any other appropriate court for an order confirming the relief as a judgment, which can then be visited upon the defendant as appropriate in their state. And they can include the reasonable expenses required to secure such an order, including attorney's fees. You can appeal not later than 90 days after the date of a final determination. A party may seek a court order vacating, modifying, or correcting the determination of the board in the following cases: fraud, corruption, misrepresentation, or misconduct. If the board exceeds its authority or fails to render a determination, or if it is established that a default or failure was due to excusable neglect, which is a standard at law. I don't know if I'm prepared to go over it here, but it is a standard. There is such a thing called excusable neglect in a case. And then they go over the procedure for challenging that. The Copyright Office, I believe, will have 1 year to implement 1 year to implement the Copyright Small Claims Board after the date of enactment. And then they commission a study after 3 years to see how things are going. So, yowza, that's going to change a lot. If you think that there's a lot of copyright suits now, what have I been doing? Like there's been 12,000 copyright John Doe lawsuits by Malibu Media and Strike Three Holdings and a couple other plaintiffs alone in the past 8 years. So yeah, this is a big deal. This is likely the beginning of a wave of, can you call it litigation? I guess it's litigation before the Copyright Small Claims Board. But it could be a good thing for YouTubers when YouTubers are the victims of some of this misconduct, the ransomware stuff, the false claims. There's various reasons and ways that it happens. You all know what I'm talking about. When that happens, now those people will have the right to file something before the Copyright Small Claims Board. And it might not be nearly as expensive to go through that as it was in a district court. As long as the then defendant agrees to go forward in the small claims court, then we can continue to save money that way, I guess. But if you still have a huge difference between the parties' wealth and power, you might still see small claimants or small defendants that are unable to stay out of district court because the opposing party, the wealthier party, knows that they can drown people or starve people rather out of their resources. So anyway, let me know what you think in the comments below. I tried to give you my comments as we were going through with it. I'm still on the fence. I'm just sort of watching this happen. I'm not in favor or against this. I haven't really formed an opinion. I like that it's somewhat neutral. It seems to be somewhat neutral. I'm not entirely sure. I really need to think about how this is going to affect the copyright landscape and whether this is going to make things better or worse or just change it. I'd like to make sure that it's making things better, but who am I? Anyway, let me know what you think in the comments below. That is my show for today. Thank you for supporting our channel on patreon.com/ljfrench and sponsors.com/law. This channel would not be possible without your support. Thank you to our channel sponsor for the month of October, Joshua Davis from TandaPay. And thank you to the $50 plus supporters for October: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. And thank you to the rest of the supporters, including the $5 supporters who are scrolling on the crawl in front of me. All of you are on the LED panel behind me. I'm Leonard French, your favorite copyright attorney. Love you all. Have a good one. I'll see you in the next one.